advertise. Appeal in Maughan and Her Majesty's Senior Coroners for Oxfordshire.
My lords, my lady, I appear with Mr Bunting for the appellant, Mr Maughan. Ms Hewitt appears for the respondent, Her Majesty's Coroner for Oxfordshire. Mr Hoff, Queen's Counsel, appears for the Chief Coroner, who's been granted permission, as you will have seen, my lord, to intervene by way of an order of Lord Justice Hickinbottom. Both the Chief Coroner and the Her Majesty's Coroner for Oxfordshire are here. My lord, in addition, you have written submissions from inquest, again granted permission to intervene, but only by way of written submissions.
Yes,
those are enclosed with the bundle, and no doubt.
I should say we've read with gratitude.
As your lordships and your ladyship will have seen, then this is an appeal against the order of Lord Justice Leggett and Mr Justice Nicola sitting as a divisional court, dismissing the appellant's application for judicial review. This appeal proceeds with the grant of permission of the court below, as you will have seen. The issues in the appeal can be shortly stated and are twofold. Firstly, whether the standard of proof for a conclusion of suicide in an inquest is the criminal or civil standard. And secondly, does the answer to that question depend upon whether the conclusion is expressed as a short form conclusion or a narrative conclusion? As to the background, that can be shortly stated, my lords and my lady. You will have seen that these proceedings arise out of the inquest into the tragic death of the appellant's brother, James. The facts are briefly summarised in the judgment below, and as to the bare facts, subject to any intervention by this court, in the narrative conclusion provided by the jury in the record of inquest, which I'll come back to. As your lordships and your ladyship will have seen, at the time of his death, James was in custody at HMP Bullingdon. He was found hanging in his prison cell at 5:20 in the morning on the 11th of July 2016, and ambulance staff were called, and he was pronounced dead shortly thereafter. Because of the circumstances of his death, the respondent was bound to undertake an investigation into the circumstances of his death. This was because he died in state custody, and I should like to take you briefly to the statutory scheme. So can I please ask your lordships and your ladyship to turn up the bundle of authorities and tab 2, please. This is the Coroners and Justice Act 2009, which establishes the scheme so far as relevant to the inquest we're concerned with. And you'll see at section 1, duty to investigate certain deaths. A senior coroner who's made aware that the body of a deceased person is within that coroner's area must, as soon as practicable, conduct an investigation into the person's death if subsection 2 applies. This subsection applies if the coroner has reason to believe, little c, that the deceased died while in custody or otherwise in state detention.
Reason to suspect.
I beg your pardon?
Reason to suspect.
Reason to suspect. Reason to suspect that the deceased died while in custody or otherwise in state detention. Did I miss out those words, my lord? I apologise if I did.
You said reason to believe.
Ah, reason to believe. I beg your pardon. And then if I can just follow that through, section 5 over the page. The purpose of an investigation under this part into a person's death is to ascertain who the deceased was, how, when and where the deceased came by his or her death, the particulars, if any, required by the 1953 Act, that's the Birth and Death Registration Act, and subsection 2, where necessary in order to avoid a breach of any convention rights, and in reality that's Article 2, the purpose mentioned in subsection 1 is to be read as including the purpose of ascertaining in what circumstances the deceased came by his or her death. I'll need to come back to this shortly in due course, but your lordships and your ladyship will be aware that Article 2 imposes an investigative obligation where the state's responsibility may be engaged. I'll come back to that because that may be relevant for the purposes of determining what standard of proof applies where a narrative verdict or a narrative conclusion is adopted for the purposes of discharging Article 2. But moving on, please, firstly to Section 7, so the next page, whether jury required, an inquest into a death must be held without a jury unless subsection 2 or 3 applies. An inquest into a death must be held with a jury if the senior coroner has reason to suspect, little a, that the deceased died whilst in custody or otherwise in state detention, and that either the death was a violent or a natural one, or the cause of death is unknown. So, obligation to undertake an investigation and an inquest required with a jury. Can I please just turn over the page to Section 10, simply so I don't have to come back to it. So it's taken slightly out of turn, but so I don't have to come back to it. Section 10 over the page, 10 subsection 2. A determination under subsection 1A may not be framed in such a way as to appear to determine any question of criminal liability on the part of a named person or civil liability. So that's the broad scheme. As to the way in which the inquest unfolded in this case, firstly, as your lordships and your ladyship will have seen, it took place between the 9th and 12th of October 2018. My client, the appellant, was not represented at the inquest, though did attend, but James's, that's the deceased's wife, Kelly Shakespeare, was represented. We have the notes of the evidence heard and adduced during the course of the inquest in the bundle, but I needn't take you to that in any detail, save to identify how the issues were framed at the outset. So can I ask your lordships and your ladyship please to turn up volume 2. And firstly, behind tab B, some context, you'll see that we have the PPO report, the Prisons and Probation Ombudsman report. Investigation will always be carried out where there's a prison death by the Prison and Probation Ombudsman. And at page 7, paragraph 7, the investigation found that staff failed to consider all of Mr. Maughan's known risk factors and did not start suicide and self-harm prevention procedures at Bullingdon shortly after his arrival, when Mr. Maughan told a community mental health worker that he wanted to hang himself, or when he said he'd cut himself and intended to hurt himself again the night before he died. One staff member did consider Mr. Maughan's risk of suicide and self-harm the night before he died, but did not have sufficient training or experience to start ACT procedures. ACT, as your lordships and your ladyship may know, is the Assessment, Care in Custody and Teamwork procedure, which is the suicide and self-harm management procedure that operates within the prison service. As to the transcript, the notes of evidence, and these are only solicitors' notes, but just to give an indication about how matters transpired. Page 22 after the next tab C. consistent with the usual way in which an inquest unfolds at the outset. We see just under the second bullet point, hole punch, requirement under Article 2 applied. So this is the coroner introducing the inquest. And then under there, I'll just recap a couple of things to deal with things, any issues before the inquest, and then other issues at the bottom. Return to Bullingdon in April 2016, because we know the deceased was in Bullingdon on 2 occasions, and concerning mental health, medication and risk, central issues, over the page, 10 to 11 July, should an act, and that should be ACCT, not ACT, have been opened. So there was an identification of some core issues, and then emergency medical response and CPR to a lesser extent. So the coroner's identifying at the outset what appear to be, at that point, some of the key issues. Again, consistent with the way in which an inquest will normally run, the evidence is heard and then submissions are heard from the interested persons as to the conclusions that might be left to the jury. And if I can ask your lordships and your ladyship to turn up page 189, which is the transcript rather than the note. And this, in the first instance, is the coroner. We can see that from the page before. The coroner discussing with counsel what ought to be left to the jury. And at the bottom of the page, next up I. Second issue is a broader issue. It's about my decisions, about which issues should go to the jury for them to consider, and indeed what is safe to leave to the jury. It's not the gold break, as you'll know, it's the Galbraith Plus, not gold break. Gold break sounds much more attractive. It's Galbraith Plus, and as you all know, that's the question, whether or not there's sufficient evidence upon which a jury could properly come to a particular conclusion, and whether it would be safe. So the plus is the whether it would be safe to leave it for them to do so. So the Galbraith Plus basis, and to consider that one needs to take an overall view about the evidence that was received, and indeed also what was set out by me at the pre-inquest reviews. Probably helpful for me to return to the note that I did, where I set out the issues. So identifying the task of the coroner at that stage, and then at page 195, at the bottom of the first paragraph, next to letter C, you'll see that there has been a submission made in relation to neglect, and the coroner concludes that it wouldn't be safe to leave neglect, firstly because there isn't sufficient evidence of the necessary gross failure, and secondly because there wasn't clear evidence of a clear direct causal connection. So not going to leave neglect. And then over the page at page 196, at the bottom of the page, the last entry is Mr. Williams. Mr. Williams represents the deceased's wife, and they're going through some proposed questions. I'll come to the questions that were ultimately agreed. Question 4, I think there's a danger, you say, is it more likely than not that he intended the outcome to be fatal? So Mr. Williams at that point is raising the question whether the question proposed to be asked of the jury might elicit a finding of intention based on balance of probability only. So it's more likely than not that he intended the outcome to be fatal. The use of more likely than not, I think, leads to that danger. It could be answered in the affirmative by the jury. If they said yes to that, then effectively you have a suicide conclusion on the balance of probabilities, and that would be a misdirection in law. Based on that, therefore, the only suggested change I would make is to ensure that they're required to apply the criminal standard. And there is then a discussion about that. And over the page, the first entry, the coroner, it would not be a suicide conclusion if it's on the basis of more likely than not. but it just
How
seems...
much of this are you going to read, Maughan? If it's a long passage, we'll quicker for us to read it for ourselves.
Then I invite you to read it yourself. The simple point to extract from this part of the discussion is that the coroner was addressed on the question whether or not the burden should be beyond reasonable doubt or balance of probabilities, where the ingredients of suicide were to be stated in a narrative. So the counsel was saying, even if you require the ingredients to be stated in a narrative rather than a short form, the fact is the beyond reasonable doubt standard must apply, and the jury should be so directed.
Well, we can read it now or later.
I'm in your hands, whatever suits.
Well, which is the relevant passage? It goes on for a little while.
So I would invite you to read page 197 in full, page 199, essentially under B, the coroner is expressing the extent of the submission and the argument, and then page 200.
Yes, well, perhaps we should just, speaking for myself, and my Lord and my Lady will say if they wanted to read it all now, I wouldn't have thought we now need to take time reading 197 to 199, we will, but 200 we probably ought to look at now, because that is his ruling.
Precisely. It's a ruling that the Galbraith standard isn't met for the purpose.
Well, shall we just look at that effectively, between the first hole punch and nearly the end?
Precisely.
Yeah. Yes, there's obviously, apart from Gold Break Plus, there's one or two other evident errors in the transcript, but none of great importance, I think. Divisional situation must be wrong, mustn't it?
Yes. A transcription error, I assume.
Yes, it's not important.
There was no discussion then about what the bench book and the coroner's guidance said.
I don't think there was, no.
That wasn't raised at that time.
That wasn't raised at that
I
time.
imagine the coroner would have been pretty familiar with it.
Yes, yes. But I'm sure he would have been.
I recall the Divisional Court saying, but I may be misremembering, that the coroner made some inquiries about the passage in the bench book, I think it is, which says that the matter is under review by the Ministry of Justice. I may not be remembering quite accurately, but
it was actually in the, as I recall, it was in the Divisional Court, and it arose through the pre-action protocol correspondence.
Thank you. Well, that's the answer.
That was the ongoing Ministry of Justice review, Mr. Bunting,
Yes.
just reminded me.
Thank you. That's what I was thinking of.
So we see at page 200, as your Lordships and your Ladyship have picked up, that the coroner has concluded that the standard, there isn't sufficient evidence on a Galbraith Plus assessment to leave suicide as a short form. Just dealing, please, with the questions, just briefly at page 204, so you will have picked up that there was an addition to question 4, and just for completeness I ought to draw it to your Lordships and your Ladyships' attention. Next to B, almost exactly next to B, 204, question 4, Lordships, question 4, are you able to determine if it's more likely than not that he intended the outcome to be fatal, or for example, if it's more likely than not that he intended the outcome to be fatal, or for example, if it's likely that he intended to be found and rescued. If you're unable to determine his intention, please say so. It's not written down there, but I would just add the following, so you might want to make a note of this. You might also, or should consider, the possibility that James was unable to form a specific intent to take his own life through mental illness. But as I've said in the question, if you're unable to determine his intention, say so. So this is the direction to the jury on intent, and the questions are found behind tab D at page 273. I needn't read them to you, but you see them, and the critical question, or at least on this issue, standard of proof, is at 4.
Well, no need to read that out because we've just seen the coroner reading it out. Yeah.
With the additional observation the coroner made that I just drew to your lordship's
Yes.
attention, and then under instructions, standard of proof, and of course balance of probabilities. The jury completed the record of inquest, and that's at volume 1, page 266, or call number rather, at 266. The medical cause of death is given under paragraph 2 as hanging, and the how, when, where and in what circumstances is given under paragraph 3. Approximately 5:20 on 11 July, James was found hanging in cell at HMP Bullingdon by the OSG, making the routine morning roll call. James was pronounced deceased at 6:20 on that day by ambulance staff in cell C217. We believe James deliberately tied a ligature made of sheets around his neck and suspended himself from the bed frame. And there's then the conclusion in the form of a narrative. Needn't read it all out to you. Your lordships and your ladyship, I'm sure, will have looked at that. But over the page, top of the page, we find that on the balance of probabilities, it's more likely than not that James intended to fatally hang himself that night. So the jury conclude that James killed himself by hanging, and that he intended to do so. Those are, of course, the ingredients of suicide, which is how we come to be where we are. And we say, having identified to the jury that it was permissible to make findings as to the ingredients of suicide, they ought to have been directed to do so beyond reasonable doubt, and simply providing the answer to the question by way of a narrative, that is the two elements in narrative form rather than short form, doesn't affect the standard of proof that applies. As to the completion of the record, as I've indicated already, that may be narrative or short form. And may I use this opportunity, please, to take your lordships and your ladyship to the Chief Coroner's Guidance, number 17 at Authorities, tab 45. At paragraphs 18 and 19. Sets out the 3 stages. I needn't read them to you, but make findings of fact. That's for the coroner or the jury, as the case may be. Distill the findings of fact into the how box. And then at 3, record the conclusion, which must flow from and be consistent with 1 and 2 above. And then conclusions, the alternative, paragraph 19. Paragraph 21 must always be sufficient evidence on a Galbraith plus. And then over the page, short form, paragraph 26, wherever possible, coroners should conclude with a short form conclusion. This has the advantage of being simple accessible for bereaved families and public alike, and also clear for statistical purposes. So the short form, in this case suicide, the Chief Coroner suggests that it would be best to adopt a short form rather than a narrative, but at paragraph 31, as an alternative, a brief narrative conclusion may be provided for at box 4. As to the standards of proof, at page...
Shouldn't one perhaps have regard to paragraph 32 of this guidance? Because this means that a narrative may be used as a brief expansion. So that might be an indication to be undesirable to have an inconsistency of approach between short form conclusions and narrative conclusions.
My Lord, I'm not sure I'm understanding the question, which is entirely my fault, I know. I beg your pardon.
Well, one of the issues in play is whether you can have different standards of proof depending upon whether or not it is a narrative conclusion or a short form conclusion.
My Lord.
I'm just wondering whether paragraph 32 might bear light on that, and as it seems to acknowledge that a narrative can be an expansion. It's not just an alternative.
My Lord, yes. So one could see...
I suspect you'll be arguing, yes, let's be consistent throughout, but please to the criminal standard.
My Lord, yes.
Because on the respondent's notice, we have the potential, as I understand it in play, that you can have different standards for short form from narrative. And I just wonder whether that fits very well with paragraph 32.
Well, in my submission, no, it
You
doesn't.
say no, it doesn't.
No, it doesn't. I mean, there must be consistency. So one could have, and indeed in an Article 2 inquest, it's not exceptionally unusual to have both a short form, unlawful killing, for example, with a narrative conclusion setting out the circumstances where that's required. And we say paragraph 32 is consistent with that position. That is, one doesn't use a narrative for the purposes, I don't mean this in any sense pejoratively, of course, but one can't use a narrative as a jury for the purposes of coming to a conclusion which is inconsistent with the short form, or would be inconsistent with the short form if the short form were adopted. And we are talking about, although the issue here is suicide, I don't think it's suggested by anybody that the approach should be different for suicide or unlawful killing. So, my Lord, that's the guidance. Can be a narrative, can be a short form. The Chief Coroner advocates a short form if possible because it has the virtue of simplicity, it's good for auditing, statistical collation and so on. Narrative may be an addition. We say it can't be inconsistent, must be consistent with the short form. So, my Lords, that's the guidance. As you all know, there was then the judicial review by my client, the appellant, contending that in permitting the jury to bring back a conclusion identifying the elements of suicide on balance of probabilities, the coroner misdirected himself. As to the way in which that developed below, you'll see from page 228 of the core volume acknowledgement of service filed by the coroner, and in the usual way the coroner's position, as indeed it is now, is formally neutral. But of course the coroner, and indeed the chief coroner, do what they can to assist the court so far as possible. And at page 239, at paragraph 10, page 239 at paragraph 10, the claimant seeks to challenge the narrative conclusion recorded by the jury in the record of inquest, insofar as it found on balance of probabilities that the deceased intended to end his life, said that the conclusion is in substance one of suicide arrived at by applying a lower standard of proof than required by law. It is uncontentious that the short form conclusion of suicide may be recorded only if the jury is satisfied beyond reasonable doubt that the deceased person caused his death by a deliberate act and intended to do so. So that was consistent with the direction the coroner gave himself. That is, can't be a short form because it doesn't meet the Galbraith plus filter, but nevertheless contended that those elements or ingredients could be recorded on balance of probabilities if a narrative was adopted. That same approach was adopted by the respondent in his skeleton argument. I needn't take you to it, but page 219 at page 221. And so at that point, the issue before the Divisional Court was there a different standard of proof applicable depending on whether a short form or a narrative were to be returned or recorded. Matters took a slightly different turn, as your lordships and your ladyship will have seen, because the court asked itself whether actually the premise of the argument was wrong, whether in fact both a short form and a narrative returning a conclusion which amounted to suicide could be returned on the basis of balance of probabilities. And we see that at paragraph 20 and 21 at page 186. So the arguments are identified at paragraph 20 and 21 at page 186. I needn't read them to you, but you'll see the way the arguments were framed, and your lordships and your ladyship may want to just flag that. And at paragraph 23, and I'll come back to this when I develop our submissions, but at paragraph 23, Mr. Bunting submitted that Article 2 does not mandate the standard of proof. We say that's the case, so the fact that we're in Article 2 territory doesn't assist the court in determining what is the applicable standard of proof, but I'll come back to that in due course to make that submission good. And then at paragraph 24, deals with Ms. Hewitt's arguments. And the second part of that paragraph, it appears illogical to conclude on the balance of probabilities that the deceased intended to end his life in the context of deciding whether his death could have been prevented, while at the same time concluding that he did not intend to end his life because the coroner is not sure of that for the purposes of deciding whether he committed suicide. So it's Ms. Hewitt's position at that point, and I think she'll come back to this in her submissions, that really there has to be available to the jury the opportunity to express a view on intent for the purposes of assisting them in concluding whether there were any failings that might have to be expressed to discharge the obligation under Article 2. Paragraph 25, however, the court say, nevertheless...
Ms. Mullihan, I'm not quite sure what exercise you're involved in now. We certainly have all read the judgment very fully. So obviously there may be particular passages you want to analyse as part of your submissions, but merely introducing us to it isn't a necessary exercise.
My lord. But the point then perhaps, if I can invite your lordships and your ladyship to extract from this, is that first of all the court recognised that simply expressing in narrative form the elements of suicide which would be embraced by a short form could not avoid the necessity of applying the standard that would be applicable in a short form. This was simply another way of expressing the elements of suicide, and the law requires that suicide, however it's expressed in narrative or short form, can only be found on a beyond reasonable doubt basis. We adopt that, we say that is right. Doesn't matter how it's expressed. If there is a conclusion that the necessary elements of suicide are made out, then the standard of proof is the same. But as you will also have seen, The court then went on to say, well, that rather depends on the premise of the argument, and the court's view was the question whether or not the standard applicable was in any event balance of probabilities.
I don't want to play word games here, but is there in fact any illogicality, as Lord Justice Davies seemed to think there was? There's no illogicality in the jury saying, we are not sure that Thomas committed suicide, but we think he probably did. There's no illogicality in that, is there?
Well, what it does is return a conclusion of suicide.
But it's not illogical.
Well, it's perhaps illogical is putting it too high, but it creates an inconsistency in approach.
In terms of perception,
Well,
you can certainly say that.
yes, in terms of perception, but also in terms of substance, because it is returning a conclusion which identifies that certain matters of fact are found, which together amount to a conclusion of suicide, but on the balance of probabilities when the law prohibits that.
Well, you say that's substance, but that it's really no more than saying that it's illogical because you're using different standards of proof at different stages. But I think you accepted that that wasn't in itself necessarily illogical. Isn't it really all about perception? Perception may be important, don't get me wrong, but there isn't really a halfway house between accepting that it's not illogical and saying that it's about perception.
But it's not just about perception, we say, it's about substance, because it is returning a conclusion which amounts to a finding of suicide, that is, he killed himself and he intended to do so, on balance of probability, and the law doesn't permit that.
Yeah.
And the same is true of unlawful killing.
Why does the law not permit it?
Because case law tells us.
You're saying case law.
Case law tells us.
You're not relying on anything in the statute.
Nothing in statute.
So it's case law.
Save that, of course, the form adopted for
Yes.
recording the conclusions contains specific reference to the standard of proof being beyond reasonable doubt, and that's annexed to the rules, and as the court in this case concluded, the empowering provision, section 45 of the Act, is broad enough to permit the rules to
Yes,
prescribe.
you haven't shown us that bit of the jigsaw yet. It may be because you were going to.
Well, I can let me do it now then. The form, your lords, my lord,
Yeah.
yes. If your lordship please turns up the bundle of authorities then, and behind tab 3, your lordships will see the rules. The rules are enacted under section 45 of the 2009 Act.
Which we have.
We don't have section
don't.
45. But they permit the making of rules.
And who are the rules made by?
They are the Lord Chancellor.
Right, thank you.
The Chief Marshal.
Could someone at some stage, just so within the bundle, get section 45, perhaps over the shortage element or something, Mr. Bunting wouldn't mind, I was thinking.
My lord, yes. Certainly. I can just tell you for your note, but I will, of course, get your lordships and your ladyship a copy. But section 45 provides that rules may be made for regulating the practice and procedure at or in connection with inquests. But I shall be sure for your lordships and your ladyship have a copy.
So it's Rule 34, is
Rule
it?
34 must make a determination and any findings required under section 10 using form 2. And you have form 2 at the back of that section, record of an inquest, notes at the bottom, identifies the short form conclusions that may be adopted, and over the page identifies the standard of proof.
Sorry, where is that?
The very last page of the extract, my lord.
Page 8 of 8. Thank you.
Yes, 8 of 8, you'll see Roman numeral 3.
And is it your submission, continuing submission, that has the status of a rule, that wording?
Yes, yes. This is attached to the rules. There was no suggestion below, and the court below didn't conclude otherwise than that section 45 permitted the making of rules which prescribe the standard of proof. And so we say that's, that does so.
You might think that the notes simply record what is the then understood state of the law without prescribing that it should be so. But perhaps that's a little bit, perhaps that doesn't really work.
Well, if one looks at the notes, Form 2 sets out what's required by way of entries, and then under paragraph 3, C note 2, paragraph 4, C notes 1 and 2. So these are central to, we say, the rules prescribing what must be included.
But yes, I've just been reminding myself what the Divisional Court said about this. They did say essentially what I have just put to you.
Yes.
But you say they're wrong.
Yes. They did say that. These are just notes recording the position. We say no. They form part of Form 2. Form 2, the requirement to complete Form 2 is mandatory. It may be that they reflect the position that was understood to exist, but they now have the effect of prescribing it too.
Pretty rum way of setting out the substantive position by introducing it in a note to a form. Unorthodox.
Well, my lord, perhaps unorthodox, but
So you say that's what has been
but there we
done.
have it.
If you link it to Rule 34.
If you link it to Rule 34, no dispute that Section 45 provides the power. Prescribes the short form conclusions available.
The respondent's notice doesn't take any point about the first half of para 47, which, as you rightly say, appears to be common ground, that the power under section 45 would enable the rule maker to prescribe the standard of proof. The only question is whether that was in fact what the rules did. Yeah.
And
No, not at all. Miss Maughan, looking at the record of inquest 266 and 267, there may be no point in this at all, but it doesn't in fact include the notes. I do wonder if a page is missing.
yes, it would have been, the form is a standard form, it would have been given to the jury
Yes.
as the whole form, and it's just this, the last page hasn't been copied.
Right. And the last page would have contained the notes.
Would have contained the notes, and assuming it followed the ordinary course, the jurors would have signed it as well.
Again, if someone could pick up a
Yeah, I'm not
copy of
sure.
that particular page over a short adjournment.
Maybe that Ms Hewitt's got it.
Well, speak for myself, we don't need it now, but if someone could do it over a short adjournment.
My lords, that was the we've seen the conclusions, we've seen the questions asked, we've seen the form that ought to be adopted, and we say appears, was adopted. Going back to the judgment, if I may, at paragraphs 27 and 28 at paragraph 188. I'm not going to read these to your lordships and your ladyship, but I want to pick up on a couple of points as we go through. Dealing with paragraph 27 onwards, dealing with the standard of proof, last sentence in paragraph 27, making clear the point, no issue is taken with this, that the applicable standard in civil proceedings, even where there's an allegation of criminal conduct, is balance of probabilities. But we say here that we are in different territory because this is an inquest, not ordinary civil proceedings. And of course, unlike ordinary civil proceedings, there's no opportunity, for example, to determine what evidence should be adduced. There's no right, though it's often afforded as there's no right to cross-examine, and there's no right to make submissions to the jury, and indeed one isn't permitted to make submissions to the jury. So whilst it's true that in a... On the facts, yes. So whilst it's true that in civil proceedings, even a conclusion that amounts to a finding of criminal conduct can be reached on the balance of probabilities, we're not in that territory. At paragraph 28, the court below identify the rationale for a higher standard of proof in criminal proceedings, of course the significance and importance of the outcome. We say the same is true here. A finding of suicide and a finding of unlawful killing is a very serious matter indeed.
Well, they are serious, of course, but so are findings in civil proceedings. It's not serious in the sense of criminal proceedings where someone is going to be punished by the state and, in a serious matter, sent to prison. That's serious in a quite different way.
It is, but in civil proceedings, one has that degree of seriousness, but with the associated entitlements, like the opportunity to adduce evidence, cross-examine, make submissions on the facts. So yes, it's serious. Here, it's equally serious, but without the protections that one would enjoy in civil proceedings. And a finding of unlawful killing against, for example, a police officer or a prison officer is a very serious matter indeed. And whilst they won't be named in the conclusion, their identity...
but you're slipping into unlawful killing, which is a finding of a criminal offence.
Suicide may result in a finding of a criminal offence where somebody has assisted it.
Well, just so I can be clear, Ms. Monaghan, are these submissions you're going to develop later and you're just trailing them? I'm not a great fan of that way of doing it. Obviously, if it comes up in the course of debate, so be it. But I think just to introduce us to the judgment, trailing submissions, if you're going to make the submissions themselves later, is a bit of an unsatisfactory.
Well, let me go to the submissions then.
Yes.
As to the submissions on law, and it may be that I'll need to come back to the judgment in due course to say why the Divisional Court were wrong.
Yes.
But let me start then, please, with the relevant authorities. First of all, you will have seen from our skeleton argument that we say there are a large number of cases which indicate that particular care must be taken in reaching conclusions of suicide in the context of an inquest. I'm not going to take you to them all, but I should like to take you to one or two. In particular, suicide must never be presumed. There must be positive affirmatory findings, and we say in the course of so holding, the authorities indicate that the burden, the standard, forgive me, is beyond reasonable doubt. Take you please to two authorities on this point. Firstly, Barber, which is behind tab 10 of the authorities bundle.
If you're right about true legal status of the notes to the form, then all your discussion on the authorities falls away.
Yes. But I'm not going to. Yes,
obviously.
Absolutely. If your lordships and your lady.
You can't assume anything,
No.
but if you're right on the form,
Yes.
then it's.
Yes, precisely.
Yeah. Sorry, tab 10?
Tab 10, Barber. A divisional court. My lord, this was a conclusion of suicide. Somebody leapt off a roof, having consumed alcohol. Court overturned a conclusion of suicide. If I can take you please to page 1313, last page in the law report. C to F, and I invite please your lordship and your ladyship to read that to yourselves. So, as your lordships and your ladyship will see, mustn't be presumed, suicide mustn't be presumed, and next to E, there is, I see, no single fact which definitely points to the deliberate taking of a man's life, and every possibility that the matter was an accident. So that's in the language of beyond reasonable doubt, we say. This is not a balance of probabilities approach. And then at tab 14, Hopper. Hopper. Again, a suicide. Conclusion of suicide quashed by the Divisional Court. I needn't take you in detail to the facts, but just so your lordships and your ladyship have it, it was a shooting. Said that it couldn't have happened by accident because there was a safety mechanism on the gun. Nevertheless, the conclusion of suicide was overturned by the court, and if I can ask, please, your lordships and your ladyship to turn up page 3 of the printout.
Yes, the opening statement of facts at page 1 is quite descriptive, isn't it?
Yes.
A happy, well-balanced young man with no problems.
Yes,
Anyway.
precisely, and those will be matters of fact that a coroner will take into account in deciding what's the proper conclusion. And at page 3, above the second bullet point, hole punch, it's of great significance. If I can ask, please, that the court read that, referring to Barber. And over the page, the first 5 lines, and then please the judgment of Mr. Justice Pill. Again, looking at whether other possibilities existed and the irresistibility of a conclusion, we say again, written in the language of beyond reasonable doubt.
Never in fact using the words.
Not in fact using the words. And we now come to those cases, we say, where those words are used, and the position is much clearer. So we have a history of describing the approach a coroner should adopt in a way which sets the threshold very high. And then the first case that counsel have been able to find where beyond reasonable doubt or the criminal standard is used in terms in the context of a suicide is Evans, and that's at tab 12. This was, you'll see the facts at page 2. I won't read them to you, but the last 2 paragraphs, in essence, the deceased was seen on a railway line.
So sorry, I just was making a note. But
So
which
we're looking,
tab?
We're looking now, please, at tab 12. And as I've indicated, this is the first case counsel can find where criminal standard was used in terms.
So this, in fact, predates Hopper.
Yes, yes. The Hopper and the Barber cases deal with no presumption of suicide. So Evans deals with the standard in terms. I won't read the facts, but your lordships and your ladyship will see when you come to read the case that this was a man standing on a railway line, train hooting, stands there with his arms up in the air, and he's knocked over. And then with next page, page 3, at the first hole punch, the Divisional Court is setting out the guidance to the jury, and right next to the first hole punch, I must now ask you to kindly retire. Now ask you to kindly retire to consider your verdict. If you consider the death occurred as a result of an accident, you should record, etc. If you think the deceased deliberately took his own life, then that should be your verdict. If you fail, then open verdict. And then on their return, the jury foreman announced that they had concluded that he took his own life. And at page 4, so the next page over, bottom of the page, last paragraph, and into page 5, deals in terms in that section, and over to page 5, with the standard of proof, even post the decriminalisation of suicide.
Well, again, is there a passage you particularly want us to read, and we'll just read it?
If you look at page 5, the first substantive paragraph, you'll see that the approach is the fact that suicide is no longer a crime doesn't make any difference, must be affirmatively proved. No stage did he refer to intention, neglected to direct them on pretension and the standard of proof, not permitted to bring in a finding of suicide on the balance of probabilities. I agree.
Yes, that's the key part for your purpose, isn't it? Because thereafter, the becomes rather ambiguous again. It is only permissible for coroner to return purposes if they find upon evidence proves their satisfaction that it ceased, intended to, and so on. That's ambiguous. So you would say it's the first two sentences which
Yes.
are critical, namely he's expressly agreed with Mr. Gareth.
Yes.
My lord, there is an express holding, we say.
You would say that's part of
It's-
that paragraph.
It's an express holding. It's not inconsistent with the observations made in previous cases that the threshold is high. You're looking at exploring whether there are other possibilities, irresistibility, and now, in terms, can't conclude suicide on the balance of probabilities. And then the next case is, which received some attention from the court below, is at tab 17, and this is Gray. This was an unlawful killing case, but in the context of this, in the context of their judgment, the Divisional Court dealt with the standard of proof applicable in a case of suicide, we say as a necessary step to its conclusion on unlawful killing. Say a death in detention at a police station. At page 476, next to D, I needn't read you to it, but there's a discussion about the definition of manslaughter, unlawful killing. And then, for our purposes, at page 477, standard of proof, just below C, I now turn to the standard of proof. Can I ask you please to read until to the bottom of that page? And over the page at 478, Mr. Hoff suggests it would be helpful for the court to read this too. So A to B, first paragraph. And you will have seen from the judgment below, paragraph 61, page 197, that the court below concluded that the observation in relation to suicide was obiter.
Well, that's really a refinement we don't need to have trouble with. We're not bound by this anyway, are we? So we don't need to much. It's quite clear it's what he thought, and it doesn't affect us whether it's formally obiter or not.
My lord, tab 13.
What can be said there about what Lord Justice Watkins says at the top of page 478? He doesn't seem to have a very high impression of what jurors are capable of doing, never mind that. But all that difficulty's gone anyway, hasn't it?
It has. The authorities now, as your lordships know,
Yeah,
ladyship
they-
knows, they indicate there's no sliding
So
scale.
that element of the reasoning rather falls away, but you say it doesn't displace what he said in the previous passage.
No. Not at all. And I took you to that because Mr. Hoff invited you to, but I recognise that that's not suggested to be of any assistance. And then at tab 13, I won't take you to all of the Divisional Court cases, but just to illustrate that there has been a consistency in approach. You have them all in the skeleton argument.
Well, yes, I was going to say, you very helpfully summarise, I think, 8 Divisional Court cases. I'm glad you're not going to take us to all of them, because they're very helpfully summarised there. But you'd like us to see this one nevertheless, would you?
I've got and one more after this. So we have a very large number, but one more after this. Again, it's a suicide case and an overturning of a suicide conclusion. And at page 777, we see again, next to E onwards, never a presumption, and so on.
Yep.
And then one last case, because again it attracts attention from the court below. Appreciate again, it's only a divisional court case and you're not bound by it, but it's, in my submission, helpful for me to say something about it. Tab 30, this is the case of Jenkins. And at paragraph, just bear with me, I've now lost my paragraph. Just bear with me, beg your pardon.
Is it 26?
I've got 17 and 26. So 17, tolerably clear, 2 principal verdicts, but in the absence of such verdicts, an open verdict was available. Standard proof for accident is the balance of probabilities, and standard of proof for suicide is beyond reasonable doubt. And I flag that for you because the court below says in terms that it's not authority for the proposition that suicide must be proved to the criminal standard. We see that at paragraph 69 of the judgment below. We say that's inexplicable because it is authority for that position, certainly so far as the court below is concerned. And then 2 Court of Appeal cases.
What would one do in a case, let us say a shooting case, where there is material whereby the jury would be required to consider both suicide and accident?
It will apply a different standard of proof.
If someone goes out shooting game and is found dead in a wood, shot,
Yes.
so the jury might have to.
Yes.
So that you apply one standard of proof to the one scenario, accident,
Yes.
to a different standard of proof.
Yes. And just as if there was a possibility that they may have been shot while out shooting by somebody else, and there was a possibility, or there was some evidence indicating that there may have been an unlawful killing by way of gross negligence manslaughter or unlawful act manslaughter, then similarly the jury would be required to apply a different standard of proof in determining what its conclusions are. Of course, an open conclusion is still available to a jury, although they are discouraged, as your lordships and your ladyship will have seen, discouraged from returning an open conclusion. Nevertheless, it is still available in the event that they truly can't decide. The next 2 cases are Court of Appeal cases. The first is McCorbin, or McCurbin. I think my Lord Justice Underhill may have been counsel in that, no?
Don't think so.
Well, then it was another Mr. Underhill. There was obviously more than one.
No, I would remember.
Tab 18, there's a Mr. Underhill representing the police officers, and indeed
Well,
it's
how
a Nicholas
odd.
Underhill.
Yes, no. Embarrassingly, when I looked at it, I didn't even notice who counsel was. And I do normally have a dim recollection of most of my cases.
It was a very long time ago.
It was how
nearly
odd.
30 years, so I think there's...
Well, I certainly was presuming it was the one and only.
Well, Yes, I see.
Well,
Russell Rose and water. Well, I agree. It is like how odd that I didn't notice, and how odd that I don't remember. Anyway, there we are. Thank you.
Underhill, but
Well, no, I don't think there's another one at the bar at that time.
well, in any event, there we are. It was
You say it has special authority.
I think it is. And indeed, it
Are
was.
my submissions quoted?
Mr. Underhill argued that the burden ought, sorry, forgive me, the standard
How
was beyond
extraordinary.
reasonable doubt. So, if I may say so.
I don't know how I missed that. Well, there you are.
So this was an unlawful killing.
This is quite an important case for present purposes.
It's a very important case because we say it's binding.
It's not a divisional court case.
It's not a divisional court case.
I'm not saying others are not important, but this is.
Yes. Well, we say this is binding.
Yeah.
It wasn't cited.
Thank you. And Mr. Hoff reminds me, I should say, of course, that it wasn't cited below,
Yes.
and it wasn't cited below because of the way in which the case developed before the court below.
Below, what counsel notified in advance that the court might not be accepting the agreed position?
No.
So to some extent it had to be done on the hoof.
It was done on the hoof, and Ms. Hewitt's nodding as well.
And no chance to put in subsequent written submissions on the file.
I've asked about that, and the answer is no. And the way that was dealt with was by way of submissions in relation to permission to appeal. So I appreciate it might have been said with the benefit of hindsight, can we put in further submissions? But presumably the draft judgments had been circulated by then, and so it was dealt with by way of an application for permission to appeal, with the court below being notified that there were these other cases that hadn't been drawn to their attention.
Because it's not unusual, is it, that after the event, counsel will think or find something and it will be sent in, so long as everyone has a chance to comment on it, it's accepted.
That wasn't done, and I mean, I can ask Mr. Bunting over the luncheon adjournment if it would assist the court.
It would have ended up here anyway, Ms. Monaghan.
It would have ended up. I think that's absolutely right, my lord. It would have ended up here anyway. Well, perhaps not. I don't know. But in any event, there we are. The main case, as we say, is McKirbin. This is a Court of Appeal authority. It's a restraint death. So arrested by police officers, restrained, died from asphyxia. And then, if I can ask you please to look at the argument, or the appeal, the way in which the appeal was framed. 721 next to the letter D. Applicant appealed on the ground that Gray was wrongly decided. Proper standard was beyond reasonable doubt. Was not the criminal standard, so in other words, the jury had not returned a verdict of unlawful killing, having been directed that the standard was beyond reasonable doubt, and that there should be no difference as between misadventure and then 723 next to E, identifying the submissions made by Mr. MacDonald, who represented the family. So next to E, contending that the jury were incorrectly directed. And then at G, contending that it's the civil standard, albeit with the sliding scale. And then, I won't read this to you, but you'll see from H over the page to E, the history of the coronial jurisdiction is outlined, and you'll be aware, my lords and my lady, that in essence, a jury on an inquisition could make the findings necessary that would found the reasons for arrest and trial, similar to a grand jury as it's described. So that's the history, not now of course. And then 727 to 728 are the operative parts. 727H, 728 to E. Approving grey. And just under D, you'll see suicide referred to.
So there isn't actually a passage which I may say Mr. Underhill submitted. It really worried me at that point. Right.
So we say, very clear holding
In an unlawful killing case.
in an unlawful killing case, and making clear too that the position is the same in suicide. So in other words, the argument that there should be a consistent standard of proof in an inquest, whatever the conclusion to be returned, was rejected by the Court of Appeal. They said no. In suicide and unlawful killing, the standard of proof is beyond reasonable doubt.
That's what it says, but it is that statement with regard to suicide part of the ratio in McCurvey.
Well, we say yes because there is a specific, the argument is framed as, should there be a single standard applicable across all conclusions? Answer, no. We adopt the position as it's hitherto been understood that there are two conclusions which can only be returned on a standard beyond reasonable doubt, a criminal standard. There is one other case that deals with suicide on the Court of Appeal in terms, so I will come to that now.
But just before we do that, two other points about McCurvey. And if we look at page 727 at letter G to H, as I've sought to indicate, whether in a case of a serious nature such as unlawful killing you adopt the standard of proof, which is technically a civil standard, but you elevate it. Now there's a finding, it is the civil standard, but then it engages in what we now know is impermissible reading, in the light of B, into a sliding scale. But there, the statement is, it is the civil standard. And the subsequent reasoning does not fit with the subsequent decision in B,
Well,
in the House of Lords.
my submission is the way it's framed is that actually it doesn't make a difference because of the elevated standard, but in fact it is the criminal standard.
But once the elevated standard is gone, and we know in the light of subsequent superior authority it has gone, it cannot be said that McCurvey has now been overtaken by B.
In my submission, no, because there is a very clear holding that while in fact it may not make a difference because the civil standard would be set so high, as a matter of law, it is in any event the criminal standard.
But it doesn't say that. It says it's the civil standard. You adopt the standard of proof, which is technically a civil standard.
My Lord, in my submission, it doesn't say quite that, if I may say so. What it says, as I've sought to indicate, whether in a case of a serious nature, as unlawful killing, you adopt the standard of proof, which is technically a standard, but elevate it, or you adopt the criminal standard, actually it's not going to make any difference.
But that's reasonings based upon a sliding scale.
Yes, yes.
And that's gone.
It has, but in my submission, the Court of Appeal is not saying it is a civil standard.
But in that case,
They are
Lord Justice Watkins has unequivocally said it's the criminal standard, but this is altogether more elusive reasoning, because it seems to be arguing by reference to a raised civil standard.
In my submission, that's
You say not.
that's not the way to analyse it. My submission is the court's saying we have to grapple with whether it's civil or criminal. As it happens, given the sliding scale, the outcome is unlikely to be any different, but in any event, our holding is that it's beyond reasonable doubt.
And are you there relying, page 728, the passage between A and B?
Yes, my lady, yes.
And then linking it further down between D and E to suicide. I'm willing to be corrected on this, but that is the only reference I can find within this authority to a specific reference to suicide.
My lady, yes.
Yeah.
And approves Gray, as Mr. Bunting's just reminded me. At the bottom of 727, you'll see that there's an explicit approval of Gray, which is the suicide case that I took yours. Sorry.
Well,
Great.
safe to say it refers to practical guidance in Gray.
Yes.
Yes, it's slight. I mean, the whole reasoning is slightly odd. It seems to slide. The 727 starts by saying, I can see there's force in Mr. MacDonald's submission. I agree, saying force in doesn't necessarily mean he accepts it. But then he says, however, whether that be right or not, what I'm absolutely satisfied is that the practical guidance is correct, meaning,
Beyond reasonable doubt.
yes, but
Is that the legal test there?
Yes.
is he not saying that's just a convenient way of expressing the highest level on what was then believed to be the sliding scale?
Well, in my submission, if there were any doubt about that, one can see that that's not what he's saying, because we see over the page, he refers to beyond reasonable doubt in terms. So while there's some interesting discussion about how this fits in a context where we have the sliding scale, the position is, just as with suicide, the burden of proof is beyond reasonable doubt.
But, by the way, sorry, you said, well, I think it was a slip of the tongue, that Gray was a suicide case.
Gray's unlawful killing,
Yes.
but they refer to suicide.
They refer to suicide, just as they do here, yes,
Yes.
but, yeah, okay.
Did I say suicide? I beg your pardon. It's the case, you'll recall, that the judges below deal with in terms.
Yeah.
Another point that perhaps might need thinking about with McKerven is that McKerven was decided before Middleton.
Yes.
And so the judges could not have had in mind that juries, as subsequently to be established, needed, in appropriate cases such as these, to look at the circumstances. Might that not have had an impact? Can it be said that McKerven's been overtaken by Middleton and now the Act?
In my submission, no. And I'll come to Middleton and I mean...
But to anticipate, you're saying it's not affected by the subsequent decision of Middleton.
And the short reason for that, but I'll have to elaborate upon it, the short reason is that Article 2 does not prescribe the standard of proof that must be applied for the return of any particular conclusion.
Mr. Bunting's submission below.
Mr. Bunting's submission below, and I'll take it. Yes, I can deal with it fairly shortly, but I will.
Article 2 doesn't prescribe a standard of proof. Just speaking of my own experience, which I accepted some years ago, it did alter the way inquests were conducted, because there was a wider inquiry and there was always this knowledge there could be a narrative verdict.
Yes, my lady, we certainly accept that. Indeed, we submit that that's the case, but we say in reaching the broader conclusions of the wider inquiry and bringing back wider conclusions if the jury think it necessary, they cannot upset the applicable standard of proof. Just as they couldn't come back with a conclusion under Article 2 which did not meet the standard, the threshold of balance of probabilities. They must come back with a finding findings which meet the requirements of the standard of proof applicable.
How are juries to construct a narrative verdict in a case where suicide or indeed unlawful killing may be in play? Applying the criminal standard, how can they do that in practice? They've got effectively to write what happened. If they have a clear view about what probably happened, you're saying they can't say it.
No, they can say it, but what they can't do is express it in a way which comes to a conclusion of unlawful killing, murder, for example.
But then aren't they then not performing the duty which Article 2 lays on them?
No, we say no, because Article 2 does not prescribe the standard of proof applicable. And case law makes clear that if they're assuming our submissions are accepted, case law makes clear that to return a conclusion which amounts to a finding of unlawful killing or suicide, then that can only be done if the jury.
Well, we know what the case law says, but the question is whether it's trumped by Article 2. What I'm just puzzling over is how, if the jury think it is very likely, but they can't say sure, that the death occurred in this way, and it is their duty to explain in what way it happened, and that involves a finding of either suicide or some form of unlawful killing. It must follow from your submission that they cannot say that. They simply will have to return an open verdict, I suppose.
No, my lord, they can, using this case as an example, they could say, and they did say, that James hung himself using a sheet in his cell. The prison officers, having decided not to open an acts for good reason, as the jury decide.
But isn't it a part of their Section 2 duty to find out whether he intended to kill himself?
My lord, no.
Why not?
Because the law doesn't require the law does not require the jury to go that far.
Article 2, I said Section 2, the slip. You're saying Article 2 doesn't require them to go that far?
It doesn't require them to find intent on a balance of probabilities. My lord, no.
But that might well bear upon one question I've asked is, did take this case, the prison authorities take the appropriate steps? And how can you deal with that unless you're asking yourselves, did he intend to kill himself? Should they have known that he intended to kill himself? You're greatly delimiting what a jury can do if you're taking that away from them.
My lord, but if I may say so, that's premised on the assumption that Article 2 would require a conclusion to be reached on intent, even where the jury could not make a finding based on a beyond reasonable doubt standard. Article 2 does not require that.
Well, you keep saying that, but why do you say that?
Because Middleton and Armine tell us, and because there is no case law, I'll be corrected if I'm wrong, but under Article 2, whether in the European courts or domestically, that requires findings to be made based on a particular standard of proof.
No, I accept that, but Article 2 does require findings to be made about all the essential circumstances surrounding the death. And one of those circumstances, one might think, was whether the deceased intended to kill himself in a suicide case. And it seems to me a bit odd that Article 2 should say that the obligation placed by Article 2 should be, well, you needn't deal with that unless you can be sure, when everything else you're doing the best you can with the evidence available, deciding what probably happened.
That is because we're assuming that the Article 2 2 function is going to be discharged in an inquest. So as your lordship says, if the Article 2 duty is discharged in an inquest, then there will be a balance of probability standard as the usual standard. Of course, if the Article 2 obligation were discharged through a criminal trial, and it may be, an inquest isn't required, if it was discharged through a criminal trial, then of course a jury would not be able to return a verdict of murder, unlawful killing, as the case may be, or assisting suicide, without being satisfied.
Yes, but in the suicide case, there may well be no criminal offence involved.
But there may be. Could be an...
No, but if there is, you're slipping away from the hard case, which is where there isn't. And perhaps we've explored this as much as we can, but it's a
I'll
crucial
take
point.
you to Amin and Middleton
Yes,
in
of
due
course.
course.
Thank you.
If I could just follow through this, we've had the one Court of Appeal case, as I've indicated, and we've looked at that. The second Court of Appeal case...
But just
certainly.
I'm so sorry.
Not at all.
Just so I
Not
can understand. So in the course of that consideration of the narrative verdict, the jury, as part and parcel of their deliberations, will need to be directed again that they must apply the criminal standard to their deliberations on whether there was intent to kill oneself. But the civil standard for other matters like should the prison authorities have done more and things like that,
Yes.
all within the same. So the kind of difficulties that Justice Watkins has been trying to avoid are then re-raised again.
Well, my lord,
You probably say, well, that's the way it goes. But it is slightly ironic.
well, we do say that's the way it goes. And of course...
Justice Watkins
Sorry.
wasn't thinking of Article 2.
Well, it wasn't talking about... And of course, what we are concerned with as well is the conclusion. So in other words, the fact that the jury may reach certain findings along the way, of course they will review the evidence, come to certain findings and then record their conclusions. Of course, as part of their deliberations, they will fact find on the balance of probabilities, but they must not return a conclusion, we say, where the criminal standard isn't met.
Ms. Monaghan, I confess I grapple with the idea that you can make specific findings of fact and there is no conclusion, whether it is stated or whether it is inferred. The conclusion is there, is it not?
The key difficulty in suicide will be intent, generally. Generally, one doesn't get to the problem, really, unless one has first determined that a person has tied the sheet round the neck. Generally, the problem will be intent. And in my submission, there is no reason why intent needs to be recorded. Circumstances, let me leave aside the authorities for the moment. There's no reason why intent needs to be recorded, or the absence of it.
When you say recorded, you mean in the narrative?
In the narrative,
So that does not need to be covered by the narrative?
yes. For the purposes of an Article 2 narrative, a jury is still entitled to find an acts should have been opened, for example.
But your submission, I mean, if you just look at the facts of this case and the narrative verdict of this jury, they do deal with intent.
Yes, and we say that's wrong. We say that intent should not have formed part of the narrative in circumstances where the standard applied was balance of probabilities.
So the the coroner should have said, members of the jury, if you are sure that he intended to kill himself, you may say so. You must say so. Must?
Well, here the coroner couldn't do that because he'd decided the criminal
Yes.
standard wasn't met, so this
Yes.
so the
all
jury
right.
wouldn't have been able to discuss
Yes,
it at all.
but let's assume it was in play.
The suicide.
Yes, he hadn't galbraithed it out.
Yes.
Should his direction have said, members of the jury, if you're sure, you, I think, must say so, or if you're not sure, you should say nothing either way.
Yes, although you may go on, well, you can say you're not sure, but you can't say you can do the negative, but what you can't do is a positive. But you can nevertheless go on to make findings on the balance of probabilities, which go to the question whether or not there are any Article 2 failures.
Yeah, I'm just thinking it's quite helpful to do this, literally in terms of what you say the direction should have been. May or must, I think that might be quite important. If the jury, should he say to the jury, you must make a finding of intent if you're sure?
It depends. It depends how the coroner decides to elicit the jury's conclusions. So if the coroner decides to elicit the jury's conclusions through a short form, then yes, he must say, if you conclude there was intent and that he killed himself, you must return suicide. But if a coroner decides not to elicit conclusions through a short form, then a jury isn't required to return conclusions that meet the threshold of suicide. I'm sure I'm being slow. There are a number of questions. The first question is, if there is a question as to intent, which, assuming all the other indications of suicide are there, will essentially be the question. The first question is, would it be right for the coroner to say short form good enough? Would that satisfy Article 2 requirements? Depends what the issues are.
Well, I know, but that's what I've said. If the only issue is intent.
Yes, the only issue is intent, and there's nothing else that can be left to the jury that will be of any significance for Article 2 purposes. The Galbraith exercise has been gone through. There's nothing else there. A short form will suffice.
So, if only issue intent, coroner should direct jury that short form will suffice and should direct only if they're sure. If, however, there are other circumstances which require a narrative verdict, he should direct them not to make any conclusion on intent unless they are sure.
No, my lord, as we saw from the Chief Coroner's guidance earlier on, and as my Lord Justice Davies pointed out, it is possible to have a short form and a narrative. So a coroner may say, if you're sure that this person intended to kill themselves and did kill themselves, you can return a conclusion of suicide. If you think there are relevant failings, then you can also return a narrative. They're not mutually exclusive.
No, I didn't mean to suggest there were, but they've embarked on a narrative verdict and do not think that the question of intent is sure, they shouldn't deal with it in the narrative verdict.
Certainly not in a positive way. Of
Yes,
course
right. They
can
shouldn't
say
make a finding of intent.
precisely.
Thank you.
Ms. Maughan, I rated you as submitting that Article 2 does not require one to deal with the issue of intent. is that right?
It doesn't require you to deal with the issue of intent on a balance of probabilities. So in other words, if you can't deal with it beyond reasonable doubt, then you can't return a conclusion of intent, and Article 2 doesn't require otherwise.
But you do accept that Article 2 may involve a requirement to consider the issue of intent. Leave aside standard.
It may do, but not at the cost of applying a lawful standard of proof, any more than balance of
I find that
probabilities.
a little unclear. In a case of this situation, does Article 2 require some consideration of the issue of intent?
Mr. Bunting is suggesting only indirectly. It's difficult to see why Article 2 would require a finding of intent. The critical issues in an Article 2 case will generally be the failings by the state. Those will be the key issues that require determination.
Absolutely, but do you accept that in this particular case, Article 2 is engaged?
Yes.
It certainly is. Right, if one then goes back to the wording of the statute, Section 5, where necessary in order to avoid a breach of any convention rights, etc. The purpose mentioned subject must be relative to the person ascertain in what circumstances the deceased came by his or her death. So why read that narrowly? Once you've got Article 2 in play, why not leave the jury to get on with determining in what circumstances the deceased came by his or her death? Because your construction is quite fettering of the jury.
Mm-hmm. Yes.
But why not just let Section 5.2 speak for itself?
Because we say that they cannot that whatever the findings they propose to return or do return, they all have to be returned on a lawful basis. So in general, that will be on balance of probabilities.
But the statute is for the purpose of ascertaining.
Yeah.
Ascertaining. That's inquisitorial language.
It is inquisitorial
And
language.
you agree, rightly, that Article 2 is engaged here.
Absolutely.
Just puzzled why one should delimit the operation of Section 5.2.
Well, because we say case law requires, as with unlawful killing, that they can only return.
You said Parliament wanted to change the settled approach. It needed much stronger language than this.
Yes, and of course, Section 5.2 was introduced in the terms that it was to give effect to Middleton and Armine, that required in an Article 2 inquiry that the circumstances be explored, not necessarily at an inquest, but the circumstances be explored. So where the Article 2 obligation was to be discharged in an inquest, broader circumstances have to be considered, but that does not upset the standard of proof applicable, whether it's balance of probabilities beyond reasonable doubt, and a jury would be permitted to say in a narrative conclusion, James hung himself with a sheet. We cannot be sure that he intended to do so. We think an act should have been opened or not, as the case may be. And the same with the police officer. We're satisfied that police officer X shot the deceased and killed him, fatally wounded him. We are not sure that he intended to do so or was grossly negligent.
Speak myself, it would be quite helpful if you have time, Mr. Bunting has time, if you could, in short form, if you have time, to formulate the kind of directions that ought to be given to the jury. I mean, we've been doing a little bit in discussion now, but if you have time to put it in writing, the kind of directions that you say should be given in the situation you're discussing it, I personally find that quite helpful.
Certainly, my lord. And they are given, of course. I mean, certainly there's no dispute in relation to unlawful killing, so far as I'm aware there hasn't been. So they are commonly given in unlawful killing cases. You must be satisfied, so you're sure, only return yes, yes. Sometimes they're done in questionnaire forms, as you no doubt know.
I think we've
And again, questionnaire form, are you sure X, Y, Z?
Sure, yeah.
No, no, no.
Yes.
Do you have any other, say, observations? It will be much more sophisticated and nuanced than that, but one gets a two-part set of directions, but certainly my Lord will draw something up by way of illustration. The next Court of Appeal case I was going to take your lordships to was Sweda Harren, and that is at tab 33. Again, court below wasn't taken to this. This is a gross negligence manslaughter case, and the interested person, the GP, argued that suicide should have been left to the jury. We see that from paragraphs 1 to 3. I won't read them to you, but 1 to 3 we see that. And then if I can ask you please to turn up paragraph 68 to 72. Again, in my submission, we see there
Sorry, what's the, you want to read the whole 68, 72?
well, 71 is the key holding, couldn't be satisfied on the criminal standard, but it's setting out the approach of the coroner.
Sorry, so does the reasoning in that passage involve Lady Justice Hallett endorsing
Yes,
that
because
approach?
yes, because we go on to page 72, paragraph 72. This was a reasonable approach, no error of law.
So the point doesn't seem to be argued here, it just seems to be taken as a given that the criminal standard applied.
That's right. It was my case of first instance. That's right.
It's hardly, you can point out that three court members didn't query the position, but the point simply taken as common ground. Yeah.
It's the only Court of Appeal case that addresses suicide in terms.
Yes.
So it's important that your lordships.
Case.
Before I come to Article 2 and Middleton and Armine, there's one last case, really simply to observe that it doesn't help, but it was referred to below, and that's Braganza. And you'll remember that the court below indicated that Braganza had the effect of disapproving Gray, that is criminal standard. And so I do need to take your lordships and your ladyship to that.
Again, sorry to add to Mr. Bunting's and Monsieur's lunchtime duties, but speaking of, I quite like to see the Court of Appeal decision in Braganza. It's in the Lloyd's report, so I'm afraid I didn't have a chance to get it if I can
So
do that.
I'll make sure that's done. You're keeping a running list. Mr. Bunting's keeping a running list.
Thank you very much, Mr. Bunting.
Braganza, you'll have seen this is not an inquest, and we say that's of critical importance because, as the authorities have made clear, and indeed as the court below accepted, The civil standard will apply balance of probabilities in civil proceedings, even where the consequence is that there's a finding of criminal conduct, or conduct that would amount to a crime if the criminal standard were applied. We're not in that territory. We acknowledge that. We say we're in inquest territory, and the position is different. And so, if I can ask you, please, this was you'll have perhaps had the opportunity to look at it, but it was a workman's compensation claim again, not entitled to benefits, death in service benefits if the death occurred as a result of the employee's own willful act, and the court had to determine what approach the employer should have adopted to the question whether or not there was a willful act, or there was suicide, putting it in ordinary language. And at paragraph 33 to 36, deals with the sliding scale point. And if I can ask you please to look at paragraph 61 to 62, which is Lord Hodge. So the first is Lady Hale, this extract is Lord Hodge. So simply, my lords and my lady, this simply deals with the standard of proof in ordinary civil proceedings, so the approach an employer should take to investigating. Evidence should reach a degree of cogency, rather introducing the sliding scale. But in any event, it doesn't help because it's simply looking at the approach an employer should take to the question whether or not there was willful conduct.
Well, it's clearly not directly in point, but there is force, isn't there, in the argument that, since it reinforces the point that my lord has already made to you, that central to the reasoning in Gray was the application of the Hornell and Neuberger sliding scale, which is no longer good law.
Okay.
Sorry. No?
In my submission, it wasn't central to the reasoning. It's that I perhaps can only state the point again, which is in our submission, the fact is the court was observing that the outcome probably wouldn't be any different because of the sliding scale, but as a matter of law, it was beyond reasonable doubt.
Fair enough, but that I think is the area where Braganza comes close to the issues we have to decide.
Well, save that, as I've indicated, we would say it's not been disputed, it isn't disputed that in ordinary contractual disputes, ordinary civil disputes, the civil standard will apply even if the conclusion is that the elements of the crime have been committed. And it doesn't take the matter any further.
Lord Justice Longmore seems to have been a bit sniffy about the decision in Gray. Paragraph 34. In the Court of Appeal, it seems to be.
Yes, because he as your lordships observed, the sliding scale issue again. And although the sliding scale is dismissed as a principle of law by Lady Hale, of course, she doesn't bound to go on to observe that the least probable an event, the more one might expect by way of evidence to substantiate it.
It's not an inquest case.
It's not an inquest case. And as we've said, of course, we accept that the standard in civil proceedings is balance of probabilities. So two more cases, Armine and Middleton. I think I've made the points I proposed to make during the course of argument, but if I could just take you to the relevant extracts. Armine is the first one in time, tab 24. This is the Mubarak case where the young man was killed in custody by a racist cellmate. And at 672, looking at the obligations imposed on the state, paragraph 31, it deals with the purposes of an Article 2 investigation, and implicitly, therefore, the scope. Doesn't make any determination as to the standard of proof. And nothing in that, we say, is inconsistent with the standard being applied in unlawful killing and suicide as beyond reasonable doubt. And if there were any, we say, if further assistance were required in relation to that, then Middleton, the next tab, this is a suicide, and at paragraph 3, I won't read it to you, but paragraph 3 just addresses the fact that a procedural obligation is imposed by Article 12. And then, for our purposes, paragraph 30, your Lordships and your Ladyship familiar, I anticipate from the questions already asked, about the scope, circumstances and so on, but simply to make the point at paragraph 30 that the Article 2 obligation may be discharged through criminal proceedings. There's no requirement that there be a jurisdiction which permits findings to be made on balance of probabilities. And so we say there's nothing inconsistent about imposing a beyond reasonable doubt standard in certain contexts. Indeed, it's certainly consistent. There's no friction.
I don't know whether this is relevant. I don't think it's one of the cases in the bundle, but I did at first instance decide a case in which Article 2, in which it was a case of a doctor overprescribing morphine to a terminally ill patient. And the doctor had been acquitted. And the coroner held in those circumstances the Article 2 obligations were discharged. There was no need for there to be a further inquiry. And I quashed that decision and said that Article 2 did require a further inquiry, essentially because the criminal that was right, does not that undermine your submission to some extent? Because
Was it a first instance decision, my lord, or were you
it
sitting
was
in the Court of
certainly,
Appeal?
certainly a first instance decision. And you're very welcome to say it was wrong if you're aware of it.
Of course,
remember
one
the
doesn't
name.
know the facts of that case. Mr. Bunting does know it. I gather it's called Moss.
Yes, that's right.
So we'll have a look at that over lunch
Yes,
as well.
it may not take us anywhere, but I mentioned it in case it does.
Yeah. And there may be cases, we would say, where the Article 2 investigation isn't discharged by criminal trial, but when one looks at what's required by Article 2, that discreditable conduct is out there in public, that there's been an investigation, and so on. Even in the case of an acquittal, those requirements may be met. They may not have been met in Moss, but they may be. It's a matter that would depend upon the particular context, what the issues were,
Yes.
what's left, and so on. We simply make, so simply the simple point is, it may be discharged through a criminal process, an acquittal or a conviction, and there's nothing inconsistent about the Article 2 duty and the standard of proof of beyond reasonable doubt, albeit that a criminal trial in some cases may not discharge the full obligation, but that will depend on the circumstances.
There are generally much stricter rules in criminal trials than civil trials as the admissibility of evidence.
Yes. And even then, it may be sufficient to discharge the Article 2 obligation. So even having regard to the fact that the evidence that will be put before a jury will be much more closely filtered, and maybe much.
Well, I mean, we better look at it. That was the issue in Moss, and as I recall it, it was because of the way the trial had gone in Moss. I don't remember quite what the detail was, but I held that it didn't satisfy the Article 2 obligation. Anyway, it's not binding on us, but it's merely illustrative that it's not quite straightforward to say, well, if there's a criminal trial, that's the end of the
Oh,
matter.
absolutely not.
You're not
No,
saying-
no, and I'm not suggesting that for a moment.
No, I understand that.
Yeah.
I'm just
and
exploring.
I think Mr. Bunting is indicating, and I will look at Moss over lunch, but Mr. Bunting is indicating that in Moss, the fact was that there were said to be systemic issues, and those systemic issues didn't lend themselves to consideration in the course of a criminal trial. But of course, that will be very, very much depend on the particular issues.
Thank
you. My lords and my lady, that's all I have to say at the moment, unless there are any other questions from the bench. My lord.
No, not at the moment. Thank you.
My lady, subject to the court's preference, it's been agreed between those at the bar that I should go next, because Miss Hewitt is satisfied that most of what she might want to put before the court will be addressed by me. The Chief Coroner, as you know, has taken the exceptional step of applying to intervene in this appeal, and he's done so because of the general importance of the case to coroners and to many others who become involved in inquests, notably bereaved families. His purpose in intervening is twofold. First of all, to assist the court on the legal background and on inquest practice, and secondly, to ensure that the court receives full argument for and against each possible approach to standard of proof in cases of possible suicide. I should stress at the outset, and this is important for those in court, that the Chief Coroner is not positively advocating any particular outcome. He is entirely non-partisan. His main interest, as you will understand, is ensuring that the law is clear and accessible to coroners so that inquest practice is consistent and unnecessary legal disputes are avoided. And in that regard, he's also very aware that the arguments on this appeal inevitably touch on what should be the standard of proof for the unlawful killing conclusion, even though they do so indirectly. I propose to make submissions in 6 parts. First of all, some general submissions on inquest determinations. Secondly, the developing case law on the standard of proof for suicide and unlawful killing in inquests. Thirdly, arguments in favour of the Divisional Court's approach. Fourth, arguments in favour of the claimant's approach. Fifth, arguments in favour of the approach taken by the coroner at the inquest. And sixthly, unlawful killing, and why that conclusion may justify the criminal standard of proof, irrespective of what is the correct standard applying to suicide. May I begin then with inquest determinations, what the legislation requires, short form and narrative verdicts. My lords and my lady have already been shown Coroners and Justice Act 2009, relevant parts of which came into force in 2013, making provision for what issues an inquest should resolve. And you have seen from section 5.1 that the primary purpose of a coronial investigation is to ascertain the answers to 4 questions of fact. And I stress that they are questions of fact. Who the deceased was and how, when and where he or she came by his or her death. Section 5.3 states, and if you would like to look at it, you haven't been shown this specifically today, authorities to page 2. Section 5.3 states that the coroner or jury may not express a view on any other matters than those 4 questions and the formal particulars needed for death registration. That's subject to the coroner's power to make a prevention of future deaths report, which is the reference at the end of the section to this is subject to paragraph 7 of Schedule 5. Section 10 on page 4 of under this tab provides that at the end of the inquest, the coroner or jury must make a determination answering the 4 questions and a finding providing the death registration particulars. That's 10.1a and b respectively. And section 10.2 is a passage you've already been shown, precluding any determination being framed in such a way as to appear to determine any question of criminal liability of a named person or any question of civil liability at all. And
what's the rationale for A being in part of a named person and civil liability without that qualification?
to preserve the unlawful killing verdict. Parliament chose to preserve and legitimise the unlawful killing verdict because an unlawful killing verdict is a finding of criminal liability, albeit not on the part of a named person.
One of the points that might perhaps be made, I'm not sure Ms. Maughan's made it quite this way, but I think it does need answering, is this. If we look at section 10.2, it contemplates that the jury may make a determination of criminal liability. It can't do on the part of a named person, but it contemplates, it might be said, a determination of criminal liability.
Yes.
Now that can only be done in law if a criminal standard is applied. You can determine that someone has unlawfully killed someone to the balance of probabilities, but how can you determine criminal liability other than by reference to the criminal standard of proof?
Yes, and that is a point in favour of the criminal standard of proof applying to the unlawful killing verdict.
Interpretation, I'm not sure it's quite been put this way.
No,
I
it
wonder
hasn't.
whether that is an indicator of the criminal standard being in play.
It is very likely an indication that Parliament understood that to be the state of the law, because at the time that this Act was passed, there was, and there is, a host of authorities in which the criminal standard of proof has been assumed to apply to the ingredients of an unlawful killing determination. An unlawful killing determination will, because it satisfies all of those ingredients of a homicide offence and does so to the criminal standard of proof, it will be a finding of criminal liability. And Parliament was evidently intending to preserve that verdict by the terms of this section. Now, all of those aspects of the Coroners and Justice Act are substantially the same as the prior statute, the Coroners Act 1988, and most of them carry over from legislation which preceded that Act, which was an Act at the end of the 19th century that was then amended over the course of the 20th. Coroners and Justice Act, we should stress, isn't prescriptive about how determinations are to be expressed, as long as they answer the factual questions. It's the Coroner's Inquest rules which prescribes a record of inquest form that must be used, and you've seen the rule and the form. And as you have seen, the factual questions are answered by completing a series of sections on the form. The how question is answered by a combination of entries made in 3 of the sections. Section 2 for medical cause of death, Section 3 for how, when and where death took place, and Section 4 for the conclusion
So whereabouts is the form? Could you remind me, please?
It's under divider 3, the last page.
Yes, I think it. Okay.
And the 4 statutory questions are answered by a combination of the answers to 1, 2, 3 and 4, and the how question is actually answered by a combination of 2, 3 and 4.
Why do you say 4? I understand question 1 is part of how, I think. How, when and where is the statutory test. What is 4? Conclusion as to the death.
Well, take the situation where a short form verdict is included in 4, classic situation, and the word accident is written in 4.
Oh, I see.
That must be an answer to the how, or part of the answer to the how question. And in this case, the cause of Mr. Maughan's death was answered by a combination of medical cause of death, hanging, how, when and where, the short, neutral description, and then the narrative conclusion written under 4 and on the additional page.
Sorry, yes, it's my fault. I hadn't really followed through. 4, the words are a bit opaque, but note 1 makes it clear that this really means this is where you put your short form conclusion.
Exactly.
Yes, I see, sorry.
And notes 1 and 2 to the form tell the reader that section 4 may be completed with one of the well-known short form verdicts, accident or natural causes, or a brief narrative conclusion, or both. Now, a few words by way of history, which help to explain some of the approach in the cases. The short form verdicts developed from the mid-19th century. Before then, conclusions were mainly in narrative form. Coroners and juries in the Victorian era took to giving a conclusion which included one of the standard words and phrases which were used in the annual return, the document for statistical purposes.
Yes, hang on just. So early 19th century narrative.
Up to the mid-19th century, usually narratives. Thereafter, coroners and juries, as a matter of practice, began using the words and phrases from the annual return. And then for the first time in the Coroner's Rules 1953, the existing list of short form verdicts was produced in a record of inquest form. And if your lordships and your ladyship want a primer on this, it's the Chief Coroner's Guidance as Authorities, tab 45, paragraph 14. I don't take you to it, but that has some of the history. Now, the use of short form verdicts has the beneficial effect that inquest conclusions are standardised, they can assist with statistical reporting of death, they're easily understood. It should also be noted that nowadays a short form verdict will be entered in the register of deaths after an inquest. That's not something required by statute, but it happens as a matter of practice. Even before the incorporation of the European Convention of Human Rights, it was always possible for a coroner or jury to use a brief narrative rather than a short form verdict in section 4, and that was recognised in the Jameson case in the passage which we cite at paragraph 25 of our skeleton. I don't need to turn that up, but before Middleton came along, one sometimes had one or two sentence simple narrative conclusions in place of short form verdicts. So in summary, from what we can take from all of this is that there is no magic in the difference between short form and narrative verdicts. They are both means of answering the how question through the form that's been prescribed. May I now move on to the effect of the European Convention? As Lordships and Ladyship know well, before the incorporation of the Convention into domestic law, the question how the deceased person came by their death in legislation was always read as meaning by what means they came by their death. And that was a question narrowly focusing on the immediate physical means of death, to the exclusion of underlying and contributory factors. As the Court's also well aware, the right to life in Article 2 has a procedural element, one aspect of which is a requirement for Member States to establish independent investigations into certain categories of death, notably those for which the state or its agents may have been responsible. And that aspect is summarised in the first 3 paragraphs of the judgment in Middleton. Again, I don't take you to it because it's well established. An Article 2 compliant investigation must satisfy a convention law standard of effectiveness. And it was that standard of effectiveness and its interpretation and effect on national law which took up the Court's time in the Middleton case. And in summary, the House of Lords concluded that where the state's obligation to conduct an Article 2 investigation is engaged and the inquest is the main means of it being discharged, the statutory provisions were to be read down so that the question how the deceased came by his or her death was to be read as meaning by what means and in what circumstances they came by their death. And that's all set out at page 202 of Middleton. And the purpose of reading down in that way was to satisfy the convention law standard of effectiveness by allowing the key issues of fact in the inquest about the death, about the circumstances of death, to be resolved.
A distinction that Ms. Monaghan made, or at least hinted at, was suppose someone dies in the custody of the state. There may be a number of questions that are important about that. The situation must be investigated in the first place, obviously, because they are in the custody of the state. One of the questions will be whether the state took sufficient care, had the right mechanisms, ACCT and so forth. But that Article 2 does not logically require anything beyond the fact that they killed themselves and that what precautions were or weren't taken. It doesn't require, because this is nothing to do with the state, the question of whether when they killed themselves, i.e. weren't killed by an inmate or prison officer, what their precise intentions were. Do you adopt that distinction, or what do you have to say about it?
Well, I'll develop this later, but the short answer is that intention may be one of the key issues, and in some cases may have to be resolved, and it would be an odd and potentially unfair restriction upon the role of a jury to refuse them the opportunity to answer that as part of their set of conclusions. And incidentally, I should add that in resolving the key issues, Middleton doesn't say that one only answers questions about state involvement. It would lead to a rather imbalanced sort of inquiry if that was the case. So, for example, in the Hillsborough case, the argument was made by Sheffield Wednesday, you shouldn't answer questions about us because we're not a state body. But of course, in order to produce a fair set of Article 2 compliant conclusions about the involvement of the state in the form of the police, questions also had to be answered about the involvement of Sheffield Wednesday. But as I say, I'll develop this submission specifically about intention a little later.
Thank you.
So in Middleton, Lord Bingham recognised that to answer the broader question properly, a coroner might give or elicit from the jury an expanded form of narrative verdict which could now address underlying and contributory causes. So in a prison death case, not only the fact that the person had died through hanging, but in Middleton, the fact that proper precautions to prevent self-harm weren't taken. It's since been established that the Middleton approach applies to certain categories of case automatically, and that one such category is self-inflicted deaths in prison. Otherwise, the Middleton approach applies only where it's arguable that substantive Article 2 duties of the state have been breached. And that's in cases like Humberstone and Letts that those principles have been established. The Middleton approach, as you have seen, was given statutory force by the Coroners and Justice Act.
We don't have Letts in the bundle, do we?
We haven't put Letts in the bundle because we were trying to prune the bundle of authorities which only cited agreed entirely uncontroversial propositions, but we can certainly produce Letts if it would assist.
So, I could you just repeat what you just said? I didn't make a comment.
Since Middleton, it's been established that the Middleton approach applies to certain categories of case automatically, and that one such category is self-inflicted deaths in prison. Otherwise, so outside the field of automatic engagement of the Middleton approach, that approach only applies where it's arguable that substantive Article 2 duties were breached by the state or its agents. And the Middleton approach, as you've seen, was given statutory force by the Coroners and Justice Act through Section 5.2. So looking at practice in inquests today very briefly, in inquests which aren't governed by the Middleton approach, which are the majority and which of course include many cases of possible suicide, it is still commonplace to see the how question answered by a combination of a sentence or two summarising the facts of death in Section 3 of the form, and a short form verdict being chosen by coroner or jury and inserted in Section 4. But even in those inquests, one does sometimes see a short factual narrative in Section 4, either instead of or as well as a short form verdict, and that would give a brief causal account of the death. In inquests which are governed by the Middleton approach, there'll often be a longer narrative conclusion saying how and in what circumstances the person died. Where a jury is involved, the coroner may prepare a questionnaire, as in this case, which will be completed and may be either annexed to the record of inquest or result in a narrative that is itself annexed, as here. And that will usually be a relatively simple document. The Hillsborough example you have in the bundle is naturally at one end of a spectrum of complexity, because that was obviously a very long and complex case. May I, against that background, turn to the developing case law on the standard of proof for suicide and unlawful killing, and beginning with cases before the mid-1980s, before Evans. Before that unreported case of Evans, we're not aware of any authority which addressed the standard of proof applying to suicide conclusions in inquest directly. And I've put in our skeleton at paragraph 36, and we've put into the bundle from tab 49 onwards the relevant extracts from editions of Jarvis on coroners going right back to 1898. What those extracts show, without taking you through them, is that before the 1940s, the principal concern of practitioners was with the point that a finding of insanity would negative a verdict of suicide, or felo de se. The authorities were therefore primarily concerned to address, the authors were therefore primarily concerned to address the evidence required for insanity. And that's understandable that everybody was focused on that at that time, because until the times in the 19th century, a verdict of suicide without a finding of insanity could lead to the person's assets being forfeit, and even the rather barbaric practice of the person's body being buried under the highway with a stake driven
They
through
couldn't be
it.
buried in consecrated ground.
Exactly, exactly. And it was only by legislation, I think 1823, that that practice was removed. The same points are made in the Wright report of 1936 and the Broderick report of 1971. That was the focus. So it's not surprising that until the middle of the 20th century, the focus was not on standard of proof, but other aspects. Then from the Lockley case in 1944 to the Barber case in 1975, there was a line of cases establishing that suicide, and in particular suicidal intent, should not be presumed and should not be lightly inferred from the circumstances of death. I'll look at just a couple of those after lunch, but I'd make 4 points about those cases before the short adjournment, if I may. First of all, the wellspring for them all was the civil case of Southall and Cheshire County News. Secondly, none of them directly addresses the standard of proof, although Ms. Monaghan is certainly right to say that a couple suggest a high degree of cogency of proof is required. Thirdly, the courts were particularly objecting to coroners who found suicide because it was difficult positively to find another explanation of death, positively to formulate an accidental explanation. And that's an error similar to the Sherlock Holmes fallacy, which was famously exploded in the Popey M case, the idea that one eliminates all impossible causes and whatever is left must be the cause, no matter how improbable. And the fourth point we'd make about those cases is that even in those cases, no fixed rule was laid down preventing suicide being found on the basis of circumstantial evidence. Now, I see the time. Would that be a convenient moment?
Yes.